Okay, so we're going to start with Chapter 1, Phase 2, Chapter 1. These are Notes A, starting on page 2, which is Chapter 1, the evolution of ownership. History of land ownership. So let's go back to how the structure starts. Everything is from the UK, so it's English medieval law. Everything that comes from colony structure from the UK has come to Ontario. It's colonized. Basically what's happening here, there is a doctrine of estates. These are the set principles and policies that are followed till today. So now when we go to the country, we will have concessions, we will have lot numbers, we will have lots that are in certain areas, whether they're along the water or not. So we'll cover that. We'll cover that structure in a few chapters. So now the growth of estates. The old English medieval term was called tenure. Tenure's growth of estates. Your third paragraph. This is involved in holding land, but you're not actually owning it. So in the olden days, you would be allowed to live on a piece of land. You'd be allowed to farm on it and grow your fruits and vegetables. You would actually pay a rent to the government, which was a taxation in those days. Right. So you essentially never actually owned it. You were just making payments to the king. The estate is the extent of the real property. Certain rights are associated with a tenure. So there's certain rights that you have, like you can obviously raise your family, grow crops, store your belongings there. You can't actually allow to share that land according to the King's law. And so it's like more of a per family, per household situation.
So no sharing of tenants?
No, there wasn't really any sharing allowed. They wanted every family to pay tax separately. Common law. These are laws that are commonly understood by people. Some of these laws might not be written down and practiced or administered, but these laws are commonly understood by individuals. Okay, that's what the common law is referring to in this case. All right, so now let's cover estates that are classified into a couple of general headings. Okay, so in this case, there's about 7 of them. Now, so if you live in a detached house right now, if you live in a detached home that is without a land lease, nothing connected to it, that's known as a fee simple. That fee simple provides you with the most rights and least limitations. So you can have a barbecue in your backyard, you can plant flowers in your front yard, you can put up a tree swing, you could put up larger balloon capacity items for celebrating something in the backyard. You could have a pool. These are all without the restrictions of any other property. Okay. Now, if we look at a fee simple with conditions, for example, now these could be, it could refer to 2 different situations in this case. So if we have a fee simple with conditions, it could contain to a certain event that it might be restricted to, like a historical home. It could have a history protection act on it, or it could not be in contradiction or in connection with today's current laws and public policy. So if things in the olden days were okay, it might not be okay right now. So that fee simple might come with new conditions. Okay. So what you'll see is there's a new plaza that I just saw the other day. What they did was they took a historical home. They weren't allowed to take it down, so they built a plaza around it, and they incorporated the historical home building as the entrance to the plaza. Okay. Now we'll look at fee tail. Fee tail was used in the olden days. It's not used anymore. This was for an heir, so this would be for like your oldest son. He would inherit the property, and that would be the only person that would take over the property, according to a fee tail. Now, a leasehold estate is you are a tenant renting from a landlord for a limited time period. Now, a leasehold estate is pretty much like any rental or any lease. It's very similar to any structure of that nature. Now, when we look at the next one is the life estate. This refers to that you are living in a property for your life, and you're entitled to do whatever you want according to the bylaws and all of the things that are that will keep you in regulation. But at the event of death, that property no longer would belong to that individual. It would go on now to the future estate, which would be the next person to take it over. So now we're going to talk about that, which is the future estate. The future estate normally arises when the life estate ends, so the previous one has to finish, and then it'll allow you to go into the future estate. So if you left the property, you're 110 years old, you leave the property to your son, he's going to become the future estate when your life estate is ending. Okay. Now with the future estate, it's not essentially going to not have restrictions as well. Most of it is a entire fee simple. Like the person that's taking over the future estate is usually allowed to do everything. So they can sell a property, they can tear it down and build something new, they could dig up the land, they could do combined things, any one of those. So that would basically be almost like a new life estate coming from the previous life estate, but now it's known as a future estate because it wasn't their original one.
Right.
Then we look at the next point, which is estate to uses. So in this case, obviously, we're talking about a trustee or a beneficial owner. So I could say I'm buying a property for my niece currently who's 5 years old, and I would like to leave her the property when she turns 21. So I have a trustee, could be a lawyer, could be myself, could be another family member. They could be in charge of that property until that person or individual becomes of age and is now then able to take over the property and do things. According to the book, this tells us that this estate to uses has fallen into disuse. So it seems that a lot of people these days don't use it as much or no longer use it anymore. We look at the chart at the bottom of page 2, which is the leasehold and freehold comparison. The leasehold is a lease and can go up to 99 years. That's what like Tim Hortons and McDonald's usually do. They'll take a really long lease so they don't have to look at escalated rents as inflation increases their profits. So they'll go ahead and sign a lease, and they can sign with a guarantor. They can guarantee it. Also, it should be for any specific time period. It can be for 1 week, a month, a year, 99 years, or whatever the case is. So any kind of lease that's established according to the provincial laws. Okay. And a freehold is you basically have an interest in the real estate, and it's for an infinity time period, so it's forever. That's exactly what a fee simple is, or what we also describe as a life estate. It's the same kind of scenario. We'll look at page 3 now. We got concurrent ownership. So concurrent ownership is explaining to you that when you have 2 or more persons owning a property, we have 2 scenarios. The first scenario is joint tenancy. Joint tenancy allows you to take the title at the same time. You're taking possession relatively at the same time. You are having the same interest or equal interest in the property, kind of like a married couple. Survivorship, what happens is if one person passes away, the surviving individual takes over the complete ownership. That's a joint tenancy. Tenants in common is simply just a possession at one time, and there's no survivorship. So that means there's a scenario where someone passes, now that person has to go and establish a new ownership type of scenario or new lease type of scenario in that case. It's referring to mostly ownership, but there's also many different kinds of ownership. It could be for recreational property or a timeshare, so the tenants in common could maybe apply more in that, where it's a partial residence, it's not a full-time residency. Tenants in common, as you know, it's only one unity is needed, is possession. Joint tenancy, you need 4 things at the same time. You need title, you need time, possession, and interest. So they have to basically own it equally or in a relatively equal sense. Now, when we look at joint tenancy, again, this is referring to tenants in common. It's against everyone else but in the possession of a single owner. So joint tenancy in itself, they all still have equal rights, but it can become a single owner at some point when it separates, right? When we look at something called severance, that turns into joint tenancy. If you have a property that you own together and you sever it in half, that's going to become a tenancy in common. Okay. Joint tenancy and the interest, they can't be transferred. The joint tenancy is automatic at death. Okay.
What do you mean by automatic at death?
So a joint tenancy says that the interest, you can't start changing it because of a will, it would automatically transfer at the time of death, because if there's a will in place, it'd have to be after the fact, after the estate's divided. So effectively, it says here the deceased joint tenancy's interest ceases to exist. Okay? So spousal interest is described into matrimonial home, which we'll cover in more detail. But matrimonial home and spousal interest are really in connection with joint tenancy. Okay? So you've got tenants in common in the next paragraph. That's the last paragraph of page 3. It says here that it involves 2 or more people owning, and then unlike joint tenancy, it is when a deceased person, they do not pass over the survivorship at all. It's treated as an asset of the deceased estate. This can usually apply in a scenario where maybe there's 2 friends owning a property together, but they are not, matrimonial home, or they're not a husband and wife. So some of the laws don't apply in that case. So that would change the use of that scenario. Matrimonial home. So just so you do understand, if you get married and move into a house together for 1 day, it's a matrimonial home automatically, and everything you have there is 50-50 by law. So unless you sign a prenuptial agreement, that's the only thing that can change that option. And any property you acquired before you got married is protected, so you don't actually have to split that property with your spouse. So if you moved into a home today and you're married, and you bought property together or after you're married, that's going to be subject to the equalization of the payments of the net family property. That means that whatever you own will be divided equally upon a marriage breakdown. So the marriage would have to break down first before that happens. So this is all except, of course, if you have a prenuptial in that case. Condominium and co-ops and co-ownerships and partnerships are all covered in our phase 1. So condominiums, we know what they are. We understand that co-ops is with or without shared capital. Co-ops are basically, if you could imagine a building with 4 apartments in it, and you were going to buy one, you would also own 25% of that corporation. That would mean shared capital. Or you may not get shared capital, and that would could still be a co-op scenario. You would actually have a board of directors in that building of 4, and they would have to vote you in. So you would be voted in as a majority so that they accept you. These kind of apartments, the co-ops, are usually found like Bathurst and St. Clair or Forest Hill. They're not common anymore, so you don't see them a lot in other parts of Toronto. Co-ownership is you're owning maybe a recreational cottage with a friend. That's a co-ownership. Partnership, there should always be a general partner in most cases, and you can have a limited partner, and that could be an investor only as well. And that's a scenario. And let's just put this on pause for just a moment, and we will continue.